I've created two prior videos on an Ohio legacy trust, which explain everything you see in the screen here. So if you have not yet watched those videos, feel free to go back and reference them. One of the questions I'm often asked here is, the legacy trust sounds great, Elliott, but what about estate taxes? Well, the legacy trust as structured here does not protect against inclusion within someone's taxable estate, meaning that estate tax would be owed on assets within a legacy trust, again, as structured here. But there are other options. So there's something we can create called a SLAT. It's short for Spousal Lifetime Access Trust, which you can tell then why it's shortened because the name's quite long. But we can create a SLAT, which is a trust which is irrevocable. And that trust doesn't pay anything to the creator. As you can see, the creator is now gone, and there are only assets that can be distributed to the spouse, children, and grandchildren. But what's nice about the legacy trust and how we can structure it, we can allow for a SLAT to be created out of the terms of a legacy trust. And let's take a step back here and think about why we would do that. Why wouldn't we just create the SLAT right away? Well, right now, in 2023, as I record this, the estate tax exemption per person is almost $13 million, $12.9 million. And for married couples, it's effectively times 2 because there's portability and they can stack those exemptions on top of a deceased spouse's, a deceased spouse's exemption can pass to the surviving spouse and stack on top of their exemption. So that's a lot, over $25 million. But right now, the law is set to sunset at the end of 2025 and could be reduced by half, which means there could be a significant reduction in the estate tax exemption on the horizon. So we have uncertainty because the law could be extended, the law could be modified, or the law could lapse. Those are really the only 3 options. It seems likely the law will probably lapse. So there might be clients who think, well, likely doesn't sound like certainty, and it's not. So what do we do in the interim? Well, what we could do is we could structure a legacy trust that has the power to terminate rights. And when those rights are terminated by the creator, it would convert into a SLAT. And at that time, a gift tax return would need to be filed. And it could be used in such a way where it reacts to the next election, or it could be used in such a way that up to the end of 2025 or close to it, while the exemption's high, a fairly easy document could be signed that says, I hereby terminate my rights. And now part of the SLAT, or rather part of the legacy trust, is now converted into a SLAT. So what we could do is we could even have a partial conversion of the legacy trust into a SLAT. So it could be for 3 million of assets within the legacy trust, 1.5 is converted into a SLAT, and that way it's outside of the taxable estate, and 1.5 stays in the legacy trust portion and still has all of those benefits that I referenced in prior discussions. So at this time in 2023, and really up until the end of 2025, we do have a great option to address the uncertainty that is before us. And that is for people who want creditor protection, for people who also might have a taxable estate if the law reverts and the current standard goes away. What we could do is we could put assets into a legacy trust, and then based on the results of the 2024 election, based on the way the political winds appear to be blowing in 2025, all the way up until close to the end of 2025, if there's a need, we could effectively revoke or terminate a piece of the legacy trust, revoking rights that the creator has and pushing those assets into a SLAT, which would be built into the legacy trust. So it provides a lot of flexibility in addition to creditor protection.